Good afternoon, good evening, as the case may be. My name is Diana Tsutiva. I'm one of the two co-chairs of the Dispute Resolution Interest Group within AZL's umbrella. We unite and organize AZL's members who are interested in cross-border dispute resolution and international law. We are delighted to have organized this session entitled Protecting Human Rights Through International Adjudication. By way of a very short introduction into the topic today, as human rights considerations now rise in the various areas of international law, the role of international adjudication in protecting human rights has also been growing. In this session, we will talk about the role of the International Court of Justice, investment arbitration tribunals, US courts, and some other fora. We will also talk about the new HAGUE Rules on business and human rights arbitration that were published in December 2019. Because of the format, the virtual format, we will introduce our speakers as we go through their initial interventions that will focus on the different facets of this topic. And our goal is to explore as keenly as possible the various aspects of the topic. I now turn the floor over to my co-moderator, Jennifer Permisley. Jennifer?
I'm back. Sorry about that.
Jennifer, I turn over the floor to you now.
Excellent. Great. So we're going to start off with Judge Bruno Simma. Judge Simma is a professor of law and a much sought after arbitrator in both public international law cases and investment treaty claims alike. He previously served a 9-year term as a judge of the International Court of Justice. And prior to serving at the ICJ, he served on the Iran-US Claims Tribunal. He has acted as both counsel and as arbitrator in cases involving many of the issues we're going to speak about today. So we thought we would start with a general question for Judge Simma about the ICJ's historic role in promoting and protecting international human rights throughout the globe, and some context on as to how that role has developed and what its role is looking like right now as we move on in the world. Where is the ICJ situated, and where do you see it going from here, Judge Simma?
Hello, everybody. Thanks for giving me that topic, in which, of course, I'm very interested myself. You know, when the United Nations were created and the ICJ built into the UN system expectations that the ICJ would play an important role in the human rights area were, let me say, muted. There's a nice story that at the second session of the Human Rights Commission in 1947, a proposal was made by the UK. Let's have the ICJ render advisory opinions about individual human rights, then go to the General Assembly for implementation. And the rapporteur from Australia said this idea was demolished within a short period of time. That was the expectation. And I think the important thing to start with is that, of course, the treatment of human rights questions or the human rights keeping the ICJ busy would go hand in hand, would more or less be mirrored by the role that human rights took up at the UN at the global level. So the more important human rights became, the more human rights issues came before the ICJ. In that regard, we can distinguish different phases. In a very first phase, the ICJ mentioned human rights here and there, and actually some of these incidental statements are well known, like in the Corfu Channel case, humanitarian considerations, in a case dealing with mine laying and warships and all that, or the Tehran case later, Barcelona traction, all about business, all about investment. And then suddenly there comes this erratic block on obligations erga omnes, particularly in the human rights field. Okay, in a second phase, human rights problems were problems that led to a case before the ICJ, and the ICJ dealt with some aspects, but these aspects were mainly institutional or organizational aspects or questions of lawmaking. For instance, all of you will be familiar with the genocide reservations to the Genocide Convention case. Of course, Genocide Convention, human rights, fine, but what the ICJ developed was the law on reservations to multilateral treaty in the collective interest, or human rights, let's say in the peace treaties case or in the Congo-Rwanda case. So the case deals with other matters. Human rights come in. Human rights are very important, but the case, the ICJ deals more with legal questions, sources of human rights law, issues of human rights treaties, and the like. Then later on, more and more cases have human rights elements. Nuclear weapons advisory opinion in the mid-90s, the Wall opinion in 2004, the Congo-Uganda case, or the genocide case, of course, in 2007. But I would say the genuine human rights cases, I see them, and I was actually fortunate to see some of them when they came to the court and how they were treated at the court, would be cases like arrest warrant in 2002, Yalo 2010, the Georgia v. Russia case 2011, a case of which Belgium brought against Senegal and which was decided in 2012, or the case of Germany versus Italy also in 2012. And if you look at this, if you look a bit closer to this case, you see they fall into two groups. One group could be considered, all right, these are human rights success stories. So like say Belgium versus Senegal, and of course now, and I'll get to that case in a second, the Gambia versus Myanmar case. But there are other cases in which I think you could say the ICJ puts human rights into place. It says you go to the back row because I'm going to refer or deal with more traditional issues of international law, and then I'll tell you what your role is, and your role is going to be limited. And of course, the primary case in this regard would be the case of Germany versus Italy, where the court made it clear, listen, if you want to find custom as to what Italian courts can decree on Germany, state immunity enjoys a priority. I mean, I know that I'm steering always on the verge of oversimplification, but you have a possibility to ask me questions afterwards. And then 10 years pass, no great human rights issues pop up at The Hague. And now you have Gambia versus Myanmar on the treatment of the Rohingya minority or group in Western, and a few months ago, the court adopted provisional measures, very much in the sense or according to the what the Council for Gambia wanted the court to say, and these provisional measures were adopted unanimously, and I think this is remarkable. This is remarkable. But in a later statement, which I hope I'll have the opportunity, I'll say a few words of caution, because of course I would love that case to go to the merits, and I think it will go to the merits. But it will be a difficult thing for the ICJ to decide whether a state deserves to be called to have commissioned a genocide. I think genocide is about the most appalling, the most severe accusation or crime accusation to make to a state, or a crime committed by a state. And I've had the dubious pleasure of sitting through the treatment by the ICJ of the genocide case brought against Serbia by Bosnia-Herzegovina. And I think I know what I'm talking about in that regard. So I'm very, let's say, I would, if I had to make a bet whether the Gambia will win that case, so to say. I would be careful about the sum of money I would bet here. But on the other hand, I would be very happy if I lost that bet. Maybe I should just leave it at that stage and keep a little time for why I have all these, let's say, second thoughts or little question marks to make on the court.
Thank you very much, Judge Simma, for this very insightful overview. Let's move to a different forum, the U.S. courts that have been historically important for adjudication and promotion of international human rights. Our next speaker is Professor Penny Venetis, who is the Dickinson R. Du Bois Scholar at Rutgers Law School, where she's been
Diana, we may have lost you, so perhaps
U.S. law.
Penny, there you are.
So,
okay.
Professor Venetis, where do we stand today with U.S. courts and their treatment of and promotion of international human rights?
Thank you, Diana, and it's great to be on this panel. I'm going to talk a little bit about some history to bring us up to date, and then, sort of in the next round, I'll talk about looking to the future, and we can't really understand what needs to happen in the future until we understand sort of the historical progression of U.S. courts' treatment of international human rights law. So anyway, I have to start by saying that shamefully, the United States has ratified very few international human rights treaties, a small handful, and even the ones that as a nation we've ratified, we've attached so many reservation, understanding, and declarations, RUDs, that means that the treaties are really nothing more than words on a paper. You can't sue to enforce the treaties in the United States. And a lot of my scholarship really focuses on this. How can we, how can we make sure that the provisions of the treaties are carried out if our Senate is really sort of unwilling to pass laws that would actually make the treaties actionable in the United States? So for the most part, treaties exist on paper. International human rights treaties exist on paper to the extent that the U.S. has even ratified those treaties. In 1980, so I'm going back now, quite a few years, there were even fewer treaties that had been ratified. And a group of very creative lawyers at the Center for Constitutional Rights brought a lawsuit called Filartiga versus Peña-Irala. And they brought it under a statute called the Alien Tort Statute that was enacted by our very first Congress in 1789 and signed into law by George Washington, our first president. So it's an old statute that really sat on the books dormant for roughly 200 years. And the statute is very, very simple. And it reads, the district courts, which is federal courts, shall have original jurisdiction of any civil action by an alien, that means a foreigner, for tort only committed in violation of the law of nations and a treaty of the United States or a treaty of the United States. So it's a one-line statute that was enacted 200 years ago with almost zero legislative history. And basically historically was enacted so that the rest of the superpowers, or the superpowers that existed then, England, France, Spain, that were across very treacherous waters, could see the United States as a place where they could conduct business, where the courts were open, and where they could get a fair shake. And that would be the federal courts as opposed to the state courts, which really sort of had no interest in international affairs, but the federal courts would be available to any alien, quote unquote, who had been injured, and they could get a fair shake. So in 1980, a lawsuit was brought, and the Second Circuit Court of Appeals decided a landmark case called Filartiga versus Peña Irala. And that case was, the facts of that case were that in Paraguay, a young man, Joelito Filartiga, was captured and tortured because of his father's political beliefs, and was eventually murdered. And the family tried to seek justice in Paraguay and couldn't. Fast forward a few years, and the victim's sister was living in New York and literally ran into the person who had tortured and killed her brother. So she sued with the help of the Center for Constitutional Rights under the Alien Tort Statute, which had sat dormant for 200 years. Like, no one had ever used it in 200 years. And in a wonderful opinion by the Second Circuit Court of Appeals, the court said, yes, you can sue under the statute. Look at the plain meaning. You're an alien. So the person who was suing was not a U.S. citizen. And you have suffered a human rights violation, the violation of the law of nations, which is a body of international law that transcends treaty law. So it doesn't have to be codified in a treaty. It can be, but it transcends international law. And you can sue for money damages. And this really was a revolution. And I just want to read the final paragraphs of the opinion, because again, it really takes us back to a different time where the United States was much more receptive to human rights, caring about human rights, and the courts were interested in adjudicating human rights violations. So anyway, this is Judge Irving Kaufman, who was Jewish and probably served in World War II and probably lost family members in the Holocaust. So this is Judge Kaufman at the end of the opinion, allowing the case to go forward. Anyway, so he says, in the 20th century, the international community has come to recognize the common danger posed by the flagrant disregard of basic human rights. And in Filartiga versus so the right to be free from torture. Spurred first by the Great War and then the Second, civilized nations have banded together to prescribe acceptable norms of international behavior. From the ashes of the Second World War arose the United Nations Organization amid hopes that an era of peace and cooperation had at last begun. Though many of these aspirations have remained elusive goals, that circumstance cannot diminish the true progress that has been made. In the modern age, humanitarian and practical considerations have combined to lead the nations of the world to recognize that respect for fundamental human rights is in their individual and collective interest. And then it goes on and on. But those words really set the tone really for the next 20 years of how the federal courts dealt with human rights violations. There were many landmark cases that were brought under the Alien Tort Statutes, both against individual torturers and rapists and murderers, as well as against corporations. So the quote that I just read really sort of embodies then President Jimmy Carter's embrace of international human rights law, and the US seeing itself as part of a global community, and also the world looking to the United States as really a leader in human rights and civil rights after the passage of landmark legislation, the Civil Rights Act, the Voting Rights Act. So the courts followed suit, particularly because many of the judges who had been appointed were appointed by presidents who had the same worldview, post-World War II worldview of respecting human rights. In 2004, that was the first time that the Supreme Court actually heard a case brought under the Alien Tort Statute. And essentially, so that was 24 years after Filartiga was born, it basically affirmed Filartiga. It mentioned Filartiga multiple times and affirmed the general principles of Filartiga. The court did say that only a narrow set of human rights violations could be heard by the federal courts, but it didn't specify which ones, and it really gave the lower federal courts the power that they had enjoyed for 24 years to continue to determine what situations that arise in the 21st century would satisfy the requirements of a case that had been written in the 18th century. So the Supreme Court really put its stamp of approval on human rights cases in the United States. One of the areas that developed in this human rights law in the courts was not only could individuals be held liable, like the Paraguayan torturer, but corporations, whether corporations could be sued for violations of human rights law. The first case was a case called Doe versus Unical against an oil company that had basically colluded with a government to build a pipeline and to protect the pipeline against the local residents by killing them and raping them and enslaving them to work on the pipeline. And the Ninth Circuit Court of Appeals said that case could continue. Several other cases against corporations then followed, and there was all of a sudden that galvanized corporations to really, really fight alien tort statute cases. Like, an all-out effort, coordinated efforts, and the George W. Bush administration really, supported those efforts. And one of the arguments that the corporations raised was that the alien tort statute does not contemplate actions against corporations. That doesn't really make sense because it doesn't say, it says you can sue any bad actor. It doesn't say that it has to be a person. It doesn't say who the bad actor is. And there had been case law that has been developed in the civil rights arena that allows people to sue corporations in the US for civil rights violations. Anyway, the corporations kept advancing the position that they can't be sued for violations of international human rights. And they kept losing. And then until the Second Circuit, which gave us the Florida case, decided a case called Kiobel. Now, Kiobel was a Second Circuit case where the Second Circuit said that corporations can't be sued for violations of international human rights law. That case went to the US Supreme Court because several other federal courts said that wasn't true, and they disagreed with the Second Circuit. When the case went to the Supreme Court, after hearing arguments on corporate liability under the ATS, sent the case back and said, no, we want to completely reevaluate the alien tort statute. And the case was rebriefed and re-argued, and the Supreme Court said it never decided the issue of corporate liability, but it severely narrowed the ability of federal courts to hear human rights cases. So it did away with 24 years worth of jurisprudence and said basically that only a narrow band of cases can be adjudicated, human rights cases can be adjudicated by federal courts, and only cases that, quote unquote, touch and concern the United States in significant ways could be heard. So basically the Florida case that had been ushered in 24 years worth of jurisprudence and human rights was swept away because the Florida case would never ever pass the test that was articulated in the Kiobel decision. Just sort of a final point, 4 years after Kiobel was decided, the US in 2018 heard Doe versus Unical. And in that case, not Doe versus Unical, Jessner versus Arab Bank. And in that case, the issue was the corporate liability issue came up again. And in that case, the Supreme Court said that that foreign corporations can't be sued under the ATS. So US corporations in theory can still be can still be sued under the ATS, although we're not sure because 2 justices said they would just overturn all of the ATS jurisprudence. 5 justices in the majority really criticized the Alien Tort Statute as well, and talked about a case that had been issued a few years earlier that said that corporations can't be sued under the Torture Victim Protection Act. So anyway, so things look pretty grim in federal courts right now for human rights cases. And then when I return, I'll talk about how we can get around this and how we can continue to support international human rights principles in domestic courts. Thank you.
Thank you, Penny. So we're looking a little bit at the different possible forums for adjudicating human rights. And so we're going to move now to an effort that is a new effort, maybe a new path towards adjudication. And Professor Ursula Kriebbaum will tell us about this. She's a professor at the University of Vienna, and she was a member of the drafting team for the Hague Rules on Business and Human Rights Arbitration. She's also served as a legal expert, as an arbitrator in multiple cases involving human rights issues and investment claims. And so, Professor Kriebbaum, we want to ask you to tell everybody what are the new Hague Rules on Business and Human Rights Arbitration, what are their goals, and how might we think about those as applying to helping us adjudicate some of these issues?
Thank you. Yeah, let me start with the goals of the Hague Rules on Business and Human Rights Arbitration. Actually, the project dates back to 2013. And as we have just heard from Penny, it was in that year that the US Supreme Court ruled in the Q-Bell versus Shell case that the US Alien Tort Statute has no extraterritorial effect. And it denied victims of human rights abuses by companies access to the US courts to obtain damages for alleged violations. So as a consequence, the idea arose that arbitration could be used as an alternative route for dispute resolution available to corporations and right holders to resolve their disputes in the business and human rights field. The City of The Hague sponsored the project of developing such rules, and that's why they are called the Hague Rules on Business and Human Rights Arbitration. The drafting team designed them with a focus on the special requirements of human rights disputes. So their aim is to provide a dispute settlement mechanism that is in accordance with the UN Guiding Principles on Business and Human Rights from 2011. Pillar 3 of these UN Guiding Principles deals with the victim's access to an effective remedy, and it has been given less attention so far. That's where the rules want to close a gap. The rules want to provide a non-state-based, non-judicial remedy for victims ex post under Pillar 3 of the UN Guiding Principles, and at the same time, they want to offer businesses a possibility to fulfill their obligations under Pillar 2 and ex ante offer a remedy for human rights abuses committed by them or in their supply chain. So let me therefore highlight some of the key differences of these business and human rights arbitration rules from the ancestral arbitration rules that we use as a model to start to work with. The process of drafting the Hague Rules required the drafting team to navigate between a variety of goals, sometimes in tension with one another. First, the drafting team needed to keep in mind the function of the rules in both providing reparation for victims and at the same time in assisting businesses in managing risk. Second, it decided to change the ancestral rules only when needed, but also to change them wherever change was needed. Third, the Hague Rules had to provide flexibility and generality to deal with the multiple kinds of proceedings that might be coming up: business to business, victim to business, third-party beneficiaries, ex-ante consent versus ex-post consent. However, they also needed to provide clear guidance for specific situations related to business and human rights arbitration, for example, concerning witness protection. As a result, the drafting team made sure that the rules would be very flexible, but also included new specific provisions. Fourth, The rules need to respect the autonomy of the parties, which is an essential trait of arbitration, while providing some clear default rules to reflect special aspects of business and human rights arbitration and the requirements of the United Nations guiding principles. As a result, the drafting team sought to balance these two ideas. For that purpose, it drafted new provisions on transparency while providing for model clauses that give the parties the option to choose their own procedures. Further changes to the Int'l rules concern issues like the selection of arbitrators with appropriate expertise for business and human rights disputes, as well as a special code of conduct for arbitrators. Throughout the drafting of the rules, the teams paid special attention to the potential imbalance of power of the disputing parties in business and human rights disputes. Therefore, various provisions of the rules deal with issues of inequality of arms between potential parties of a dispute and reflect this concern. This relates, for example, to representation and assistance, an obligation for the tribunal to manage the proceedings proactively, a possibility to create special mechanisms for the gathering of evidence and protection of witnesses, and rules on fees and expenses. The rules provide in Article 46 for a specifically adapted provision on how to identify the applicable substantive law. And the rules require that the tribunal satisfies itself that an award is human rights compatible. So how will these rules now apply? What about consent? As in every arbitration, also a business and human rights dispute can only be resolved by arbitration if all of the parties involved consent to arbitration. So how can this consent be established in case of a human rights violation? There are a variety of different possibilities. In some of them, consent will be given before the dispute arose, but it's also possible that the parties enter into an arbitration agreement after a dispute has arisen. Let's assume that a company and its supplier, let's say a shoe producer and its suppliers, have a contractual dispute that involves a human rights issue, such as unhealthy working conditions in the premises of the supplier. There will be a supply agreement that will usually include an arbitration agreement. This could provide for arbitration based on the HAGUE Rules on business and human rights arbitration, and in this way, the company would comply with its obligation under Pillar 2 of the UN guiding principles. And if it has the opinion that its supplier doesn't live up to the human rights guarantees it acted in its supply agreement, then the company can sue its supplier based on the business and human rights arbitration rules. Another possibility would be an agreement like the Accord on Fire and Building Safety in Bangladesh that had been concluded after the Rana Plaza building collapsed in 2013, and that could provide for arbitration based on the business and human rights arbitration rules. And these rules also provide for a possibility that in this arbitration agreement, one provides that third parties have standing if the arbitration clause provides for that. Another possibility would be international organizations like the World Bank or the IMF could require that companies that receive funding have to agree to submit to arbitration under the Hague Business and Human Rights arbitration rules to be in a position to receive this funding. The same is true for national development agencies or foreign investment insurance companies. All those could condition funding or insurance on an offer to arbitrate by the company vis-a-vis potential victims of future human rights abuses by the company benefiting from the funding or insurance. Local communities that contract with local or foreign investors, for example, in the sector of public services, could require that the local or foreign company or the foreign parent company provides for an offer of consent to arbitration should their activities lead to human rights violations. The same is true, for example, in the mining sector, where states could condition licenses to mine upon an offer to arbitrate under the human rights arbitration rules by the mining companies. So these are just some examples, and these rules have an annex, and this annex to the rules contains a number of examples of model consent clauses for these various constellations. And I leave it there and address some fields of specific importance for these rules in the second round. Thank you.
Thank you, Professor Klebaum. Can you hear me?
Yes.
Thank you so much for this very, very insightful introduction of the HAGUE Rules, and we'll talk a little bit more about them later. But I'd like to now move into a different context, and this is investor-state arbitration, where the issues of human rights have been coming up, I would say increasingly so. Based on what's publicly available, one of the interesting recent cases was the Obesa versus Argentina, where for the first time the Investment Arbitration Tribunal asserted jurisdiction over Argentina's counterclaim, which was based on human rights. And even though that claim did not survive on the merits, it did survive on jurisdiction. And so we've been seeing that those issues come up a lot in the context of international investment agreements. And in this context, I'm really delighted to have Professor Toby Landau join us as a speaker. Professor Landau is a barrister, advocate, and arbitrator. He's a member of the bars of England and Wales, Singapore, New York, Northern Ireland. Professor Landau has extensive experience sitting as chairman, co-arbitrator, sole arbitrator in commercial investor-state arbitration disputes, and has done so under the world's most leading institutional rules and ad hoc arbitrations. As counsel, Professor Landau has a broad commercial and international practice, both in London and Singapore. He is a visiting professor at King's College London and a member of the court of SIAC, as well as the member of the governing board of ICA. And I can continue on, but I think that it would be more interesting to hear from Professor Landau on the question of how have human rights come up in the context of investor-state arbitration, and what are the current limits to adjudicating human rights through investor-state dispute settlement system.
Thank you very much for a very, very kind introduction. Very, very tempted just to leave it there, actually, but I'll now carry on and reduce everybody's expectations. I think in order to understand the role of human rights in investor-state arbitration, you have to first set the scene as to the nature of investor-state arbitration and why it's different from any other kind of arbitration. The best way to think about investor-state dispute resolution is to think of it as a vertical as opposed to horizontal exercise. In ordinary arbitration, you're normally dealing with parties who are at the same level as each other. For example, contracting counterparties. You'll have one entity contracting with another entity, they have a dispute, they go to arbitration, and their dispute is about their own particular universe, their own relationship. What makes investor-state arbitration unique is it is vertical. It is an investor, whether it's a company or individual, bringing a claim against a host state, not on the same level. And therefore, it's much, much more like a public law regulatory exercise. The complaint could be about any aspect of the exercise of sovereign discretion, whether it is legislative, executive, or judicial. And of course, the impact of making a complaint against a state may be felt much, much beyond the limits of that individual dispute. If you are accusing a state of having misconducted itself, then the impact of any decision may be felt by a whole community, possibly an entire population. And so we're dealing with a mechanism that has a much, much broader potential impact. And that's why human rights is relevant, because of that potential impact on others, which may or may not be relevant even for the immediate parties. That's in the context of investment treaties that, at least in their early incarnations, were made up of very broadly worded standards. So tribunals are mandated to test the exercise of sovereign discretion by reference to standards such as fair and equitable treatment, or full protection and security, or non-discrimination, without any real guidance as to how to calibrate those standards. And that is a powerful mandate, because tribunals are in a position to sanction state conduct. They can do so by reference, by damages awards. They are not subject to appeal. They're limited review opportunities, and this often leads to mandatory recognition and enforcement. So, unlike international commercial arbitration, this is a powerful beast. But what is curious is that it is dealt with through the prism of international commercial arbitration, because the procedural mechanism that has been applied to it is a commercial arbitration model, which doesn't actually take account of broader concepts such as human rights. Now, if we take that context and look at how this area has developed, there are really three categories of case where human rights have been raised. One is where human rights are relied upon as a defense. That is where states deploy human rights as a way of limiting their responsibility under treaty standards. In the Abeza case, which has already been mentioned, that was taken one step further, where Argentina not only used human rights as a defense, but also as an affirmative counterclaim, which in a very, very rare instance was allowed in terms of jurisdiction, although not on merits. So you've got human rights being used by states to say that there are limitations on what they are obliged to do under investment treaties. Secondly, and in a new wave of cases, human rights are being deployed affirmatively by investors as a basis for claiming against states. The current example of that is the pending Al Jazeera case against the state of Egypt, which raises issues of freedom of expression and freedom of media and the treatment that Egypt has meted out to Al Jazeera's journalists. And then lastly, and most challenging of category of case, are those cases where human rights are not raised by anybody. And yet the tribunal is conscious that the impact of its decision may well have an adverse impact on the human rights of entities, individuals who are not actually present in the immediate dispute. Just very, very briefly, this leads one naturally to a range of limitations. There are procedural limitations and there are substantive limitations in investor-state arbitration, which are problems for raising human rights. Very, very quickly, procedurally, the commercial arbitration model is simply not set up for it. And so actually, unless one party argues it affirmatively, it's very difficult for a tribunal to raise it itself. Most tribunals actually are not minded to do so. And substantively, investor-state treaties do not actually mention human rights. And so there is a question as to how human rights norms feed in to the substantive protections and the provisions of treaties. And I think I'm going to leave it there just because I think we should open up for the second part of the debate, but that sets the scene.
Thank you, Toby. So I think we've heard about several different forums. Maybe none is the perfect forum for everything you might need to address. We do have some audience questions that we want to try to bring in to our final part of our discussion here. And so I'm going to switch out of the planned order for a moment and go to Professor Kribaum. We wanted to understand a little bit more, and some audience members wanted to understand a little bit more about the procedure under the Hague Rules in terms of bringing claims and whether or not states have to affirmatively consent, who bears the financial burden, what is intended in terms of how this will work in practice. And this goes to a larger question we have in the second part, which is how do the processes work and which processes can really be used effectively to adjudicate human rights?
Okay, as far as the question is concerned and who pays, the rules on fees and expenses of arbitrators and allocation of costs contain provisions that allow tribunals to take into account situations of economic imbalances, so usually trouble for the victims, and therefore the Hague Rules attempt to lower the barriers to access to a remedy. Still, parties will need a minimum of resources to cover the basic costs of the arbitration and their own representation. This can be done either through own resources or through a legal aid system, through contingency funding if allowed in the country of the state of arbitration, or an agreement on the asymmetric distribution of costs and deposits between the parties. And we have provided for model clauses regarding costs. They are to be found in the annex to the rules. But so we tried our best, but some funds will be required. I mean, what one could think of is also external funding. So third-party funding is possible. There are certain requirements that come with that. And of course, the UN or whatever other organization could set up a fund in the future that helps to finance such arbitrations, or law firms could do it pro bono. But if this doesn't happen, then of course, money is an issue. But we really tried our best to lower the barriers, and also to kind of point out to the tribunal that they shall take that into consideration. And for instance, do not reserve unnecessarily costly meeting rooms or things like that. Yeah, but there is a certain limit that you need, that we were fully aware of that. Do we need state consent? No, we don't. As in every other arbitration, what the rules need is the consent of the parties to the dispute. We need that consent, but we do not need the consent of any state so that these rules can work. And otherwise, I mean, from the starting of an arbitration procedure and from the running through an arbitration procedure, they are modeled along the lines of the Int'l rules. So you would bring your arbitration claim, and there would be a tribunal composed, and all these usual things. We just made adaptations there where we thought that they are necessary, especially to deal with these imbalances. And I also saw a question on what's the difference to the national contact points under the OECD guidelines. The national contact points, they end usually with conciliation or mediation procedures, whereas the HAGUE rules, they provide for arbitration, so the result is binding.
Thank you, Professor Kribaum. We unfortunately do not have a lot of time left, so we have to collapse some of the questions that have come in and that we wanted to raise in this session. So Professor Landau, just briefly, what is, from your perspective, required procedurally for human rights to be properly raised, heard, and adjudicated? And relatedly, is private arbitration without a right of appeal a proper forum for adjudication of human rights? You know, we've seen a lot recently backlash against ISDS for issues of limited transparency, limited ground of review, etc. Be really interesting to hear your perspective on this.
This is a very, very topical question. I think there are a number of points one has to make about this. There are particular procedural problems in the commercial arbitration model that need to be overcome in order for human rights issues to be taken seriously within investor-state arbitration. And that means that there has to be the ability for a human rights point to be argued properly, even if it is not being argued by one of the disputing parties. That's one of the key problems. And in many of these cases, there's no interest in the immediate parties actually taking the human rights point. The state may have no interest itself for whatever reason, strategic, tactical, sometimes incompetence, sometimes a lack of wherewithal, a weak team. The investor may have no interest at all in raising a human rights point for obvious reasons. And so the question is, where does the point arise? And if it doesn't get dealt with, it will simply be dealt with later as part of the backlash, because it will be a criticism of the award that it didn't take into account human rights. So it becomes very important for tribunals then to take the initiative. And that is a mindset problem. There is nothing, as far as I can see, in the law or the procedural mechanism that regulates investor-state arbitration to prevent tribunals taking an initiative. That is to actually call for assistance, whether it's experts, interveners, amici, or asking for parties to make submissions on human rights points. But unfortunately, tribunals will rarely do that because they carry with them, partly because of their training, often in commercial arbitration, they carry with them a narrow sense of what the process is. Their idea is that they are there simply to resolve the immediate dispute between the immediate parties. And the problem is that that's short-sighted because it's fed the backlash. It means that awards are rendered where people then comment and say, well, why didn't you take into account the wider potential impact? And often that's a human rights criticism. So that takes me to the other point put, which is the arbitration process actually good enough, or do we now have to rethink it? And I personally think the process is good enough, but that's irrelevant because what matters is perception. And we have lost this argument. For a profession that specializes in advocacy, we have singularly had the most amazing defeat. We have failed to argue why this process works, and now the majority of states with an UNCITRAL want to change it. And that means it must change because it does not have the legitimacy which it needs. And that means we need to rethink it. And I think that's something which is a shame, but that's a reality. So we now need to look to a broader system, and human rights is a very important aspect of it. And it will mean more transparency, and it will mean more review, possible appeals, and the ability for third parties to intervene.
So fascinating comments. And with that in mind, I want to pivot back to Judge Simma for a moment, because the ICJ was supposed to offer at least an alternative option in some of these instances. We have many questions from the audience about the limitations on the ICJ. Comments like China has a permanent presence, and also questions like, could China be held liable for the actions against Hong Kong? Is the Rohingya situation, really rising under the Genocide Convention to the level you need for something to be found here? So tell us a little bit about whether you think the ICJ has limitations that can or cannot be overcome, and what some of those are.
I look at the time which I see clicking, so to say, and in a way I'm glad I only have a little time because these questions are, of course, very, very difficult. And I intended to refer to this idea that why doesn't the United Kingdom or some other countries sue China for breaching the agreement maintaining the autonomy of the territory of Hong Kong, and questions like that. But I realize I can only more or less pick up one thing, and I think the main problem or the main reason for the ICJ not growing into a human rights court proper is that only states can appear before the ICJ, at least in contentious cases, and states simply are not the genuine born human rights defenders. Maybe they secure the rights of their own populations, their own people, but for a state to go to The Hague and sue another country for breach of human rights of that very other state's population is something that will remain very rare. And what I personally find very interesting is that even in these cases, like Belgium against Senegal, or the Gambia versus Myanmar, if you really look closely, you see there is always a special element that you could call it a political element or a link that is added to this pure interest of a state to go to a court, not to pursue its own matters, but in the community interest. For instance, in the Belgium-Senegal case, some of the people that had been tortured in Africa by the guy whose extradition from punishment or extradition from Senegal was at issue, had acquired Belgian nationality, or that Belgium at that time had these nasty juges d'instruction, which led to the arrest warrant case, which also led to this case, that the government somehow had to digest and turn into action, which Belgium did actually admirably. And in the Gambia Myanmar case, what is a point to be kept in mind is that there is a religious link or tie between the Gambia and Myanmar. Actually, Myanmar accused Gambia before the ICJ a few months ago that the Gambia was actually mandated, was tasked by the Organization of Islamic States, because the Rohingya are Muslims and the majority population in Myanmar is Buddhist. So this is simply, I would say, a traditional reflex of states. You pursue your own interests. And so I think the need for specialized regional human rights courts will remain important, and these courts will do much more business and more important business with regard to human rights than the ICJ ever will. I see 0, 0, 0. So better stop.
So we understand we have 5 more minutes, although our clock has told us to stop. We do have a little bit more time. So
I've gone on for another 10 minutes.
It was a good mental stop for you. Deanna, do you want to address the next one?
Sure. Perhaps Professor Veneris, you could give us a bit of your insight into, having heard all of these different comments about different international fora, what's happening with the U.S. courts and how does it fit into enforcement of human rights internationally?
So there are a number of different, we talked about a number of different ways that human rights can be enforced internationally. And the key is, how can we continue to enforce human rights in the United States? I just wanted to throw out a few recommendations. I ended my prior discussion with, sort of the very grim reality that the United States Supreme Court has severely limited the ability for litigants from around the world to use our courts, which had been very open for 30 plus years, to adjudicate human rights violations. I'm very glad that there are other fora internationally for that to happen. But the U.S. law should not develop independently of international law. And so I have 2 recommendations. The first is that people can bring claims against U.S. actions or state actions by filing petitions before the Inter-American Commission for Human Rights. And although the Commission's opinions are not binding on the United States, well, they're not enforceable, they are actually binding, and the U.S. has to abide by them. And I give an example of a case where a woman who was a victim of domestic violence and had a restraining order against her husband, the restraining order was violated, and as a result, the children were killed by the husband. She sued and lost in the United States Supreme Court in a very surprising and horrible decision. She then brought the case before the Inter-American Commission for Human Rights, which issued a very scathing 100-plus page decision that really said that the way that domestic violence complaints are handled in the United States violated the provisions of international law and the American Convention on the Rights and Duties of Man. So it said to the United States, you're not doing this right, you need to follow international principles. My second piece of advice, and I think it's really critical, is for people to use the state courts. And not to necessarily bring international human rights claims in state courts, but if you're arguing a case where you can also argue a principle of international human rights law, argue it. All you need is a footnote. And we build footnote by footnote by footnote. We develop a body of jurisprudence that can be used later. Our courts, federal courts, are very conservative. I'm hoping they don't stay that way. The next generation doesn't see international law and domestic law as being siloed. They know international human rights law. They learned it in law school. And I'm hoping that when they're in charge, they will resurrect the wonderful decision that I read before, the wonderful language in Philartiga, and really will, sort of continue to expand the use of international human rights law in the United States as well as abroad.
Thank you so much, everyone. We've come to the end of our session. I really want to thank each of you for your fantastic interventions. We obviously, I think what we have established is this topic is inexhaustible and we should plan on further discussions. I want to also thank Curtis Mallet for sponsoring this, this session. Again, we hope to see you soon online and hopefully in person to continue to discuss these really important issues. Thank you all.
Thank you.
You. Bye-bye.
Bye.
Bye. Thank you.